Hi guys, this is a attempt to ensure that we are not hamstrung by the fact that all of us have different schedules, and as a result we would not be in a position to work out a convenient time for catch up sessions. So what we are going to do is to have these recordings, preferably of an hour, but because of time constraints I may also put up recordings of half an hour or 45 minutes or maybe even longer than 1 hour if time permits as much. These recordings would go through some of the themes that we have discussed earlier and which some of you would have missed. What I would suggest, and as the instruction would have already clarified to you, for each one of these sessions, we'll have certain prescribed readings. And I would recommend that what you do before you start listening to or watching this particular video, that you go through the recommended readings. And I think that would help you to have a good sense of what we are going to discuss as part of this recording. And then after listening to the recording, if you have any queries, I would suggest that you either email me or you can come and meet me and we can work out a session for clarification of any doubts that you may have based on these recordings and readings that you'll have to do. Now what we are going to do would be to introduce to you first the very basics of the course in terms of what the course outline and what are the objectives of the course. And thereafter what we would do would be to proceed to specific themes that you may have missed since they were done in the earlier set of classes. Now, not all these themes may be relevant for all of you, given that some of you have joined a little earlier than the others. But nonetheless, it may help to go through all these recordings because it may also act as a form of a revision on some of these themes. So it will not harm you to go through these recordings, even on themes that you may have already attended lectures on. So this is the basic format we are going to follow. I'll give you prescribed readings for every set of lecture. Do the readings and then listen to the lectures. And thereafter, if you have any doubts, we'll have a separate clarification session, either individual or I'll clarify the doubts by email. So this is the basic format that we are going to follow. I hope this would work well for you. Ideally, and in the previous years, I have had catch-up classes for all of you. But given the number of classes we've already had by now, the number of catch-up sessions that we would require would be fairly substantial. And given my other obligations at this moment, it may be very difficult for me to take out time that may also be convenient for you. It may be fairly easy for me to have sessions in the evenings, but then you may have other engagements at that time. Or late in the evening, it may not even be possible for the day scholars to be here. So I think this is a fairly reasonable compromise where we try and have these recorded lectures, and after that, if you have any query, we can always have individual consultation sessions. Alright then, so what we will do would be to start off with the very basics of the course, and I would recommend that you go through the course outline if you haven't already gone through it. That will give you an overall picture as to what the course seeks to do, what are the different components of the course, what are the different evaluative components of the course, some of which you may have already gone through, some others will be scheduled later. But the course is primarily aimed at being evaluated through certain exercises, certain assignments, and that's why it would be useful if you go through the course outline, because that also gives you the different list of assignments that we are going to have and a general introduction to all of them. So this is what I would recommend. But before we move to the next part of this particular session, where we'll start with the very first reading, I would suggest that you go through the first reading by Kenneth Vanderbilt, Thinking Like a Lawyer, which is the very first reading in the reading material. After that, there is a reading from Scott Slorach, chapter called Introduction to Law, where there are certain introductory concepts discussed. And after that reading, we have another set of reading called the Institutional Sources of Law, which has been prepared by me from a multiple set of sources to give you a general introduction to what are the institutional sources of law recognized in India. So before you proceed with this particular video and listen to the rest of the video, I would recommend that you go through the first three readings in the material. That's page number 1 to page number 13. It would be quite helpful if you go through that first, because then you'll have a reference point as a act of general framework in understanding what we're going to discuss here. Now, if you look at the very first reading, it's tries to sort of map out the very objective of this course, tries to map out the structure of the course in some ways. Now, since most of you have already attended some or at least one lecture, if not more than one, you would have some idea about what this course is about. The very name of the course, in fact, indicates what this course tries to do. And that is that it seeks to train you in certain basic methods of legal reasoning that we believe are unique to lawyers or that are unique to legal reasoning and are different from other methods of research or other methods of analysis. We must acknowledge that there is a significant degree of overlap between what historical research involves, what social sciences research involves, or what other forms of scientific research involves, and what legal research and reasoning involves. But that overlap is only one part of what legal reasoning entails. We believe, and as much as some may say it's a conceit of lawyers, I would think that there are certain intrinsic or certain unique forms of techniques of reasoning that are peculiar to legal research and reasoning. And what this course tries to do is to give you a general overview of those techniques and give you an introduction to what those techniques are, so that you are able to hone and sharpen your skills in those techniques over the next 5 years. Unlike many other branches of law that you're going to study in the first year, or in fact later, legal methods does not deal with any specific branch of law. So it's unlike contract or unlike tort, where you're going to deal with one specific discipline per se. Here we are not going to deal with any specific discipline as such, but rather transcend all these disciplines and touch upon many different disciplines with the aim of familiarizing you with what are those basic skills that are required for a lawyer. What are the basic techniques of reasoning that a lawyer must master if he or she is seeking to become a good, adequate, competent legal professional. Now, if you look at the very first page of the reading material, it speaks of how lawyers often deal with questions in a very different manner than non-lawyers. And we often speak of this as thinking like a lawyer. It may not be easy to describe what thinking like a lawyer means, but there are certain elements that we certainly believe are essential to quote-unquote thinking like a lawyer. And the question is, what are those? Now, if you look at a very basic issue or a hypothetical, I am perpetually distressed with the fact that my mother listens to Arnab Goswami's show on such a religious and regular basis. But if I want to stop my mother from watching Arnab Goswami's show, is there any particular legal option that I have? Now, some may argue that all right, a mother must listen to his or her son. Some may argue, on the other hand, that given how much our parents have done for us, I should be grateful for all that, and therefore I should cut some slack for my mother. And even if I don't particularly like Arnab Goswami, my mother has a choice and I should respect the choice of listening to Arnab Goswami. Some others may argue that if you want to be a good national, if you want to be a good patriot, perhaps Arnab Goswami's show is the only show that makes you a good patriot. But then as lawyers, we are not going to get into these questions. Our questions would be, is there a right that I have? Is there a duty that my mother has towards me? Is there a breach of duty that has taken place? And if there has been a breach of duty, then perhaps I may have a legal option. So similarly, if somebody gives you a case where a person, because of hunger, steals bread or steals some other food item, and the question is whether he or she should be punished, then again, we don't deal as much with the morality of theft. We don't deal with whether it's fair to punish someone for having committed an act which was driven by a compulsion of food or compulsion of hunger. What we would be asking ourselves are, what are the rights that that person has? What are the legal rights that that person has? What are the legal duties that that person has? And has there been a breach? So as lawyers, we often speak in terms of rights and duties, and we'll be spending some time later in terms of what those, or how do we define rights, what do we mean by duties, and how rights and duties are related, what are the different ways in which we classify rights. And this is something that we'll do in one of the later sessions. But we need to understand that we don't speak generally in terms of the ethical propriety of a given action. We generally don't speak in terms of the cultural acceptability of a given action, but rather we speak in terms of identification of rights. We speak in terms of identification of duties, and we examine whether there is any specific right that has been violated, or which consequently or correspondingly means whether a specific duty has been breached or not. So this is something we need to be very clear, because as lawyers, rights and duties are the weapons that we use. These are the arms that we use in our arsenal, because for us, general questions of what is desirable, general questions of what is appropriate is not the central element as much as the basic contest on rights and duties of different parties. When I try and go and argue that a particular contractual claim has not been honored, what I try and argue is that I had a contractual right which has been breached, and correspondingly the other party to the contract had a duty which he or she has breached, and therefore he or she owes me a certain obligation. It could be in form of compensation, it could be in form of specific performance. But the crux of the matter is we try and speak in the language of rights, we try and speak in the language of duties. So this is what we need to emphasize on. But the other question, or the other important insight that we need to appreciate even as we start our legal reasoning is what are the different steps that are involved in identification of any right or any duty in a given problem. So you are given a problem where person A comes to you and tells you that his coat was stolen by person B, and thereafter person B sold the coat to one of his friends C, and person A has found out that C is wearing that coat right now. So he wants to find out whether he can now claim that coat back from C. Now, if you have to find an answer, yes, what we need to find an answer to is, does A have a right to claim the coat back from C? But that would depend upon certain questions of law, or that would depend upon certain questions of fact, which will have to be resolved before you can conclusively identify the rights that have been or that are applicable and duties that are correspondingly applicable. And often we say that's why the very first exercise in any legal reasoning or any particular form of a particular exercise in legal reasoning is to identify what are the questions involved, or what we often speak in legal terminology as what are the issues involved in any given problem. So we try and ask ourselves what are the specific questions involved. So in this given example, where person A tries to recover his coat from person C, when C has acquired the coat from person B, and B has acquired or stolen the coat from person A, what we need to ask ourselves is, can theft transfer ownership? Because what has happened is B has acquired the property from as a result of theft. So does that mean that when B steals something from A, does he acquire ownership? We may also ask ourselves the question whether a bona fide, or that is a good faith purchaser of stolen goods, acquires ownership. The fact that C may not have known that the coat had been stolen by B, does that give him a right? So that would be one question that we may have to ask ourselves. We may also have to ask ourselves in terms of, can A directly claim the coat from C, or can he at best claim damages from B? These are a range of hypothetical questions that I have thrown up that may have to be answered if you are trying to explain, or if you are trying to find the answer to the basic query that the client had. Can he recover the coat from C? So that would depend upon addressing certain basic questions of property law. That may involve addressing certain basic questions of sale of goods. That may also involve certain basic questions of contractual law. But any legal problem when we get, probably one of the first step would be to identify what is the issue, what exactly is the question that the lawyers will have to answer. Because clients don't generally come with a precise question. Clients will tell what their grievance is, or what is the concern that they have brought along with them, or that impel them to approach a lawyer. But as lawyers, for us, we have to break down that fact situation into certain specific issues. And that's what we do in any legal reasoning exercise, that once we get a hypothetical set of facts, we try and work out what are the possible issues in any given case. And when we say what are the issues, we essentially mean what are the questions of law, or what are the questions of fact, or what are the mixed questions of fact and law that is involved in that specific problem. So if that part is clear, once we have identified the issues, thereafter we need to find the answer to those issues, and that again involves a range of steps. So if you turn to page number 2 of your reading material, you'd find a reference on the left column to 5 different steps that Kevin Vanderbilt, the author of that piece, has identified. He speaks of, once working out the issues, he speaks of identifying the applicable sources of law. So if the question is, does theft transfer ownership? You may have to identify what are the applicable sources of law that governs ownership. So you may have to identify relevant statutes, you may have to identify relevant case laws, and that itself involves a range of skills. It involves a range of research skills that requires, or that you would have to understand in the process of identifying the applicable sources of law. And that can be different types of sources that we'll discuss later. But apart from that, it's not just about applying or identifying the applicable sources of law. It's also about analyzing the various sources of law to determine what exactly is the relevant legal principle. So it may be that you have found the Contract Act, it may be that you have found a given case, but then that's not enough. You'll have to be able to analyze those case laws. You have to be able to analyze those statutory provisions to be able to synthesize them together and cull out a applicable legal principle that theft does not transfer ownership, or a principle that a good faith purchaser may be protected from the original owner. So, and these are all hypothetical propositions that I'm stating, but these are propositions that we cull out from statutes, from cases, from constitutional provisions, from delegated legislation, and the skill involved is in synthesizing all of them to extract the governing principle. You will not find the principle in one single instrument usually. You'll have to read a statutory provision, you'll have to supplement that by reading case laws, and then you may have to string together a range of case laws and work out the relevant principle together. And from that we get what is the governing statement, or what is the governing principle that relates to a given question. So if you turn back to one of the hypotheticals that was discussed in, or one of the real life cases that we discussed in the class today, which involved the case of Fisher versus Bell, where the question was, can display on a window of flick knives come under the prohibition imposed in the statute, where it prohibited not only sale but also offer of flick knives for sale. And there we read Contract Act, we read various statutes, we read general principles of cases on general principles of contract, and work out that mere display is not an offer, it's only an invitation to offer. So that's a principle that has been extracted from a range of cases and statutory provisions that are studied or that have been analyzed together. So that's the other major skill. So one is about finding the applicable sources of law, identifying the applicable sources of law. Next is analyzing them to work out what are the legal principles. And then comes the major task of applying the principles to the facts of the case. So not only do we find what is the applicable rule, but we also have to apply it to facts of a specific case. So if there is a question involving taxation, or a special tax to be more precise, imposed on left-handers. So there is a statute which imposes a special tax on all left-handers, and question is whether a person who writes with left hand but he does batting and he bowls, if you take examples from cricket, with his right hand, now will he be considered as a left-hander? And suppose you find in a given case law that the test of whether a person is a right-hander or left-hander is which is the hand that he uses for writing. Then we apply that principle to the facts of the current case, that this person A may use his right hand for batting, he may use his right hand to bowl, but he uses his left hand for writing. And since the test of a left-hander is one who uses his left hand for writing, then we know that this person would be considered as a left-hander for the purpose of this given statute, which imposes a special tax on the left-handers. So this is how what we have done is to identify the relevant principle from an existing case law and apply it to the facts of a given case. So that's the other step involved. So what we start off by is by identifying the issues, which would be based on a thorough reading of the facts. Thereafter, we identify the applicable sources of law. Then what we do is analyze the applicable sources of law. Then we synthesize the applicable relevant legal principle. And then we apply those relevant legal principles to the facts of a given case. So this is what we do in any exercise where we have to apply the legal or apply relevant legal principles to a given hypothetical problem or a real life problem. Now, if we take a step back, what we have done till now is to see what are the various steps involved in legal reasoning. And each one of these steps involves certain nuances. Each one of these steps involves certain techniques. Each one of these steps involves certain special skills. And the aim of this course would be to familiarize you with those basic skills. How do we research to find applicable legal principles? How do we read various sources of law to identify relevant legal principles? Then how do we use principles of logic to ascertain whether we have applied the basic principles or applied the relevant legal principles that we have identified to specific facts of a case? These are all techniques that we are going to learn in this case, or sorry, in this specific course. So this, I hope, gives you a general overview of what legal reasoning in its classical sense involves. But we also need to understand that these set of skills arise in many different contexts, and the orientation of these contexts may be different from one another. So if you look at a particular litigation, traditionally the most common context in which lawyers had to encounter problems or cases was where a problem had already arisen or a dispute had already arisen, and lawyers had to find out what is the applicable legal rules or what are the legal principles that would govern the dispute, and what are the ways in which we can come up with the best possible arguments for a client. So we already have the facts given to us, and thereafter we work out what are the applicable conclusion to the questions that these set of facts throw up. And that's the general manner in which most litigating lawyers deal with cases. But if you look at a transactional lawyer, the way most of them deal with legal reasoning would be slightly different. That the client already tells them that this is what I want. So I want to buy this property, but I don't want to pay tax, or I don't want to pay a specific form of a tax on this particular transaction. So how do I structure this acquisition in a manner to avoid taxation on this transaction at all? So then, unlike the first set of contexts that I spoke of, where the facts have already arisen and the lawyers have to find an answer to the dispute that the facts have thrown up, here what you do is you already know the answer that you want. The lawyers have to advise in structuring the facts in such a manner that we arrive at a particular result, we arrive at a particular conclusion. So in that sense, the work that a transactional lawyer may do may occasionally be very different than what litigating lawyers may do. But nonetheless, the basic skills and the basic techniques still remain the same. Then you'll have to look at applicable legal principles. You have to identify the applicable legal principles. You have to look at them. You'll have to analyze them. You have to cull out the relevant principles and apply them to a set of hypothetical facts and work out which set of hypothetical facts results in the conclusion that the client wants. And then we tell the client that this is what is the pathway that you should follow in order to structure the transaction in a manner so as to avoid the tax that you are so desperately seeking to avoid paying. So we need to understand that the context may be different. Very often you may be required to give advice to a client instead of litigating before a court of law. A lot of the work that lawyers do these days is advisory work. A lot of the work that lawyers will do would be transactional work. Often a lot of the work that lawyers will do would be compliance related work in relation to administrative requirements under statutes. But nonetheless, the basic techniques remain the same. The basic skills remain the same, although the orientation, although the context, although the objective may be different. And in that sense, even though the contexts are different, apart from differences at the margins, one would believe that the core principles and the core skills still remain the same. And the objective of this specific course would be to introduce you to those particular fundamental techniques, those foundational techniques that lawyers need to understand in competently carrying out all these different processes of legal reasoning that we just went over. Right then, so this is how we traditionally speak of legal reasoning. This is how we speak of what legal reasoning means, which is essentially about identification of sources of law, looking at statutes, looking at case laws, looking at constitutional provisions, applying them together to a case where parties have to, rights of the parties are decided in accordance with the principles laid down in those statutes or laid down in those cases. And accordingly, we apply those principles to the facts of a given case. And that's why we believe, or there is this traditional belief, that lawyers have to largely deal with cases, largely deal with statutes, largely deal with constitutional provisions. But increasingly, we need to also understand that legal reasoning is not completely independent from other disciplines. Legal reasoning is not completely autonomous and is not restricted only to technical questions of statutes, case laws, constitution, but also has very strong connections with social sciences, has a very strong connection with philosophy, has a very strong connection with economics, has a very strong connection with ethics, has a very strong connection with sociology or with anthropology. So if I may just take an example, let's say there is a constitution of a country which recognizes right to life. It recognizes the right to life and says that no person shall be deprived of the right to life. And one of the citizens in that country comes to the court and says, right to life means that abortion must be criminalized. That right to life mandates that all fetus must be protected. All fetus as living beings must be protected. And therefore, any legalization of abortion violates that constitutional right to life. And therefore, abortion ought to be criminalized. Now, if that's the sort of a plea that has come up before the court, it would involve examining questions of what do we mean by life. It would involve questions of, is fetus a living being at all? Or if fetus is a living being, at what stage does a fetus become a living being? Is it right from the very conception? Or is it at a certain stage of its development? This may involve understanding of biology. This may also involve basic understanding of philosophy. This may also involve understanding of religious debates, because at the end of the day, what we mean by life and what we mean by essential elements of life often has strong religious, often has strong ethical, often has strong philosophical undertones. And therefore, as a judge or as a lawyer, these are questions that may not be solely resolved through reference to statutes, reference to case laws, reference to constitutional provisions, but may also involve analysis of many other disciplines. And that's why we say that even as our fundamental skills that a lawyer needs would be ones about identification of legal sources, or analysis of various sources of law, synthesis of various sources of law, that does not really capture all that legal reasoning entails. And legal reasoning often has strong connection with other disciplines. And often we need to understand that the role of a lawyer is not just in litigation. The role of a lawyer is not just in giving advice to a client, but often it may involve policy work. Often it may involve designing legislation. So if I may give a hypothetical, or in fact a hypothetical borrowed from a real life example, when we had this massive floods in Uttarakhand, I think the year before the last one, there were instances of massive escalation of price of basic commodities by traders at that point of time. So you had water bottles being sold at 400 rupees per liter. We had rice being sold at 200 rupees per kg. We had vegetables which had crossed 100 rupees per kg in terms of their price. And there were many who had argued that this form of exploitative price gouging requires some form of legislative intervention. It requires some form of legislative intervention because it's completely, or at least the argument was that it's completely unethical for traders to exploit the compulsion of tourists and other local residents who were caught up in the middle of that natural disaster. At the same time, you also had people argue that it's not a business of state to regulate. What is fair price is not a question that state can examine at all. There are strong economic impact of any such interference with freedom of market or freedom of contract, that it will make market inefficient. There will be further spin-offs which may not be desirable. And there has been strong debate between philosophers on whether such regulatory interventions are necessary, whether a legislation is necessary, the economic benefits or economic costs of having such a legislative intervention. But if you, as a lawyer, are asked to design a legislation or are asked to advise whether such a legislation is necessary or not, you will not be able to give an answer purely through use of statutes, purely through use of cases, or purely through use of constitutional provisions. At such point of time, you may have to rely on insights from other disciplines. You'll have to rely on insights from economists. You may have to rely on insights from philosophers. And that's why we'll often find there are courses like law and economics. There are courses like law and gender. There are courses like law and philosophy. There are courses like law and poverty, which bring in insights from range of other disciplines in recognition of the fact that legal reasoning is not completely insulated and does not entirely work in an autonomous domain. Law is about regulating social conduct or social or institutions in a given society, and that means that a thorough, comprehensive analysis of legal questions must also involve analysis of questions from economics, questions from philosophy, questions from anthropology, questions from history, questions from gender studies. So that's why we need to understand that even as the traditional approach on legal method emphasized on certain key skills of lawyers that are unique and very different from other forms of social sciences research, increasingly, and there is a very influential school of, or more than one school of thought, which argues that law cannot be treated as an autonomous discipline, and as lawyers we must also, if not master, certainly have certain basic proficiency in other related disciplines as well. And this is an insight that we need to understand and keep in mind when we look at various other courses. And in fact, often you will have professors encourage you to link up different technical questions with broader social sciences questions. So when you study IPC, you may often be asked to look at the sociology of crime. When you study family law, you'll often be asked to look at the political and the social impact of some of those regulations. And that's again because we recognize that study of law cannot be divorced from study of other disciplines, or certainly certain related disciplines. So this is one principle that we need to keep in mind as we proceed with our analysis in this course. The other point, in fact, one of the critical points in the first reading, and if you turn to page number 2 of your reading material, on the right column you will find the author describing how often legal reasoning is not about finding one conclusive answer. Statutes, case laws, constitutional provisions, delegated legislation, all of these involve or are certainly suggestive of multiple ways of interpretation. You can read the same case in different ways. Two different lawyers can argue two different conclusions from the same case, from the same statutory provision. And often that's why I argue that law, unlike many other hardcore sciences, does not lend itself to one determinative answer. There is certain plurality, there is certain subjectivity, there is certain indeterminacy in legal analysis. And therefore, the role of a lawyer is not so much in finding that one conclusive answer, in finding that one definitive determinative answer, but to construct arguments to say that these are the best possible ways, or these are the most persuasive, or these are the most plausible conclusion that may arise from a given case. And so our role as a lawyer is to be able to convince the judge that this is what should be the final conclusion, not because this is the most determinative answer, but construct arguments through which we tell the judge that this is the most persuasive answer. And that's why the role of a lawyer very often is about constructing arguments and not just about identifying the final answer. And often we will come across cases where we may not agree with the reasoning, but we do agree with the final result. But that's not sufficient. Often we'll find the reasoning may be inadequate. And because legal analysis is about argumentation, legal analysis is about constructing reasons and constructing persuasive arguments in favor of a particular line of thinking or a particular conclusion that the client wants. Therefore, we have to be very precise, we have to be very meticulous, we have to be very careful about the sort of arguments we construct. Because our role is to construct the most persuasive, construct the most plausible, construct the most appealing arguments in support of a specific assertion. Merely stating the assertion would not be sufficient, and therefore we need to be very precise and very thoughtful about the sort of terms we use, the sort of arguments, the sort of propositions we just use to justify a specific assertion. And this is something that we will see being reflected in almost all the major discussion we are going to have henceforth. The same problem can be interpreted in different ways. So if you just tell the judge that this is how I interpret it, it's not sufficient. The emphasis has to be on constructing arguments in support and say, because of this principle, this is how it should be interpreted. Because of this precedent, this is how it should be interpreted. Because of this rule of interpretation, this particular statutory provision has to be interpreted in a given way. Conversely, for the lawyer on the other side, they have to think of arguments to rebut these claims. And I think this is something that is fairly self-evident when we speak of law or when we speak of advocacy, which is often about the art of creating or constructing arguments, the art of structuring arguments, and not just about arriving at a particular destination or arriving at a particular argument or a particular conclusion. So I hope this point is clear for you. If you go through the text on page number 2 of your reading material, it will be fairly clear in terms of what the authors say. If you have any doubt, you can always come back to me and we can sit and explain this point in some greater detail. But this is something that we need to appreciate as we proceed with the next step of our next stage of our introductory course, where we look at certain basic concepts of law, where we look at certain elementary concepts of law before we move to the techniques of legal research, before we move to the techniques of legal analysis, before we move to the techniques of legal writing. What we need to understand are certain core conceptual or foundational elements that we believe are essential for us to properly analyze, properly research, properly write or present legal arguments. And the first thing that we are going to discuss would be the definition of law itself. Now, we need to understand that definition of law, like many other aspects of this discipline, does not lend itself to any one single authoritative definition. And often the definition itself is a product of different ideas or different conceptual understanding of law. So how we imagine law often shapes the way we define law. But at the same time, we need to have a definition of law, because for us, we need to be able to understand what is that authoritative element, what is that ideational element that makes a rule binding, what is that element that distinguishes a social rule, a rule of etiquette, an informal principle that students follow within a single hostel. What is that element that distinguishes the etiquette of not accepting gifts from their left hand from a legal rule? Why do we say that the fact that we should not accept gifts from or through our left hands, or the expectation that we should say thank you every time we are given a gift or done a favor, not considered a legal rule, whereas the claim that every citizen has a right to freedom of speech and expression is considered as a legal rule? What is that element that distinguishes these two different types of cases is what we try and seek to identify through this exercise of defining law. Before we get to the specifics of it, I must say that this is a theme that we're going to discuss in a lot more detail in the final module, where we look at legal theory or certain theoretical debates on the nature of law or nature of legal reasoning. But as an introductory exercise, what we're going to do would be to look at the role of law and morals. Now, many communities provide for a rule that adultery is considered as immoral. Many different communities see adultery as immoral. Does that mean that adultery should be considered as a crime? Does that mean that adultery should be considered as a legal wrong? Must laws reflect morality? Must laws reflect what are seen as morally acceptable and morally abominable in a given society? These are questions that philosophers have debated upon for centuries. And some argue that it's morality that gives law its legitimacy. In fact, as we'll study, there is this entire school of law which argues that without morality, state is nothing different than a set of robber barons or a set of robbers. That if you don't have moral values backing a legal rule, such a legal rule cannot even be called a law. In fact, Saint Thomas Aquinas, a medieval saint, had once famously written that an unjust law is no law at all, and that itself reflected the fact that law gets its authority, law gets its legitimacy from its compliance with certain broader set of moral principles, and therefore we must believe that it's morality or its moral quotient of a norm that makes it a legal norm. And often people argue that if you look at most communities, the notions of what is legally permissible and what is not permissible under law often overlaps with what is considered in that community as morally acceptable or what is considered as morally indefensible in that community. But conversely, many others argue that that's not necessarily the case. If you look at Hitler's edicts or Hitler's proclamations as part of the Nazi regime, they were clearly immoral, or most of them were by any definition immoral, yet they were applied and they were binding on people in Germany. If you look at the South African apartheid era laws, they were laws that were framed by the parliament, but at the same time, most people would argue that laws on apartheid, laws on racial segregation, were immoral by basic principles of justice, basic principles of equality, basic principles of universal brotherhood. And yet, as far as the South African state went, those principles were binding, those rules were binding, and those rules were considered as legal rules. So the argument that it's morality which gives law its authority clearly falls flat. Because had that been the case, neither would Hitler's edicts be considered as legal, nor should apartheid era laws ought to have been considered as legal or as rules of law. And it may be that in most communities, rules of law reflect rules of morality. But the point that many other scholars have argued is that there is no necessary connection. There may be a connection, and in most communities there is indeed a connection, but it's not the same as saying that there is an essential connection, that is morality which gives law its definitive character. Had that been the case, every time we come across a law that is immoral, we'll say that that's not even a law. Every time we come across a norm that we consider as unjust, the argument would be that that cannot even be considered as a binding authoritative legal rule. And clearly that's not the way we approach manifestly unjust legal rules in very different communities, very different legal systems. And therefore it would be wrong to speak of rules of morality as being the essential element of a rule of law. Law and the definitive element of law cannot be morality. Some other scholars, and if you turn to page number 8 of your reading material, some speak of how legal rules must and do derive their legitimacy from social acceptance. That rules become legal rules when they have a wide constituency of support, a great number of a certain element of support within the community, and that's that element that turns law or turns rules into binding legal rules. And again, scholars have argued that that may often be the case. That is indeed generally the case, but again, that's not the definitive element of law. because we find umpteen examples of statutes, we find umpteen examples of legal rules that do not have any wide acceptance within that community. If you look at examples from India, when child marriage prohibition laws were imposed, most communities thought that child marriage is entirely acceptable. When dowry prohibition acts were or laws were introduced, most people thought, and even now there is a strong constituency which believes that dowry is acceptable. But that does not mean that Dowry Prohibition Act is not a legal rule, or that does not mean that child labor laws are not acceptable or not legal rules, or that child marriage laws are not legal rules. They clearly are legal rules, even though they may not have a minimal element of social support. And that again illustrates the fact that perhaps social support is not the definitive element of a legal rule. Had that been the case, had that indeed been the case, then all these all these rules would never have had the status of authoritative legal rules. So there may be an overlap, but again there is no necessary connection. And in fact, many philosophers would argue, and if you go back to Jeremy Bentham, the 18th century utilitarian philosopher, he wrote that law must actually at times be one step ahead of public opinion so as to become an instrument of social reform, so as to become an instrument of social change. So if that's the insight we borrow, then it would be very difficult to sustain the proposition that legal rules derive their authoritative character from social acceptability or social legitimacy. And that insight tells us that it's neither morality nor social support nor a wide constituency of social legitimacy that gives law its authoritative character. And in fact, many scholars argue that it's far more mundane a question. It's a simple question of pedigree. It's a simple question of form. So who has framed this rule? Is it a body which is competent or which is seen as authoritative? If that's the case, it may be considered as a legal rule. Has this body made the rule following the procedures that are seen as the necessary procedure for framing a rule? Then yes, it becomes a legal rule. So if I pass an order saying that all Barcelona supporters should be given 1,000 rupees subsidy on a monthly basis, that would not be a legal rule, even though some may argue it's fairly reasonable, or at least Barcelona supporters would certainly argue that. Some may not, and given the sheer quality, the sheer poetry in football that the club plays, some may argue that in years to come, this rule may also gain certain degree of social acceptance. But nonetheless, it would not be considered as a legal rule, because I am not someone who's considered as authoritative, someone having the authority to frame binding legal rules in the society which I live in. So every community, every legal system has certain institutions which are seen as authoritative, institutions which are seen as authoritative. And when those institutions frame certain rules, when they frame rules following the procedures that are seen as necessary, then those legal rules become binding. The institution competent to frame rules may be different in different systems. So in a democracy, in a parliamentary democracy, we believe we require parliament to frame rules. We require, in a procedural sense, the rule to be passed in two houses, then to be signed by the president and then notified in the Gazette. In a monarchy, it may be simple signature of the monarch. In a parliamentary monarchy, it may be passed by the parliament and then signed by the king or the queen. In despotic forms of government, we may have a specific dictator as the person seen as authorized to frame rules. Or in cases of little more enlightened despots, we may find this power being shared among a range of institutions. But nonetheless, in every community, we have certain institutions that are seen as competent to frame legal rules, that are seen as competent to form legal rules by following certain procedures. So if that has been done, many scholars argue that a rule becomes a rule of law, an authoritative rule of law, as distinct from a social rule, as distinct from a cultural rule, as distinct from a religious principle. And that's why if you turn to page number 4 of your reading material, where they look at a dictionary meaning of law, they speak of the most common definition, that's it's a body of rules, whether formally enacted or customary, which in a particular state or community recognizes governing the actions of its subject. So it's a system of rules, or it's a body of rules meant to govern the action of its subject, but it's framed by the institutions that are seen as authoritative in that community. And then they also speak of which is enforced by imposing penalties. And we'll see each one of these elements at a later stage. We will see each one of these elements in the final module, where we'll spend some time on different schools of legal reasoning, and we'll look at the merits and demerits of each one of these approaches in some detail in the final module of this particular course. But at this juncture, you need to understand that the very widely accepted definition, a very widely held definition within the positivist framework, is that it's a body of rules that are imposed through the force of sanction, through the force of penalties, but these are framed by institutions that are recognized as authoritative in a given community, that are recognized as authoritative by the virtue of certain reasons accepted in that community. And if such a body is framed a body of rules, those body of rules become rules of law. And in that sense, we would be looking at what are the accepted or what are the recognized institutions that frame laws in India, and what are the different institutional sources of law that all lawyers must understand and all lawyers have to habitually confront in Indian legal system. But please do understand that this definition is only one definition. Many scholars have a problem with this approach also. Many argue that penalty or sanction is not the central element of law. In fact, we can think of international law as an example, where penalties are not always applicable, and yet we speak of international law as a branch of law. There are many others who argue that this particular definition does not tell us which is that element that makes institutions authorized. So when we say in India democracy, because we are a democracy, it's the parliament which is allowed to frame a law, or which is mandated to frame laws, and only laws made by the parliament are authoritative. Then what happens if there is a military coup and the current constitutional structure is overthrown? Then will we say that the orders of the military dictator now becomes the law, because military dictator is one who is authorized? So what is that source of authority? Is it mere power? Is it mere brute force? Is it mere coercion? Or is there a deeper source of legitimacy? Is there a deeper source of authority which makes certain institutions authorized, or certain institutions seen as recognized and authorized in a given legal system? And this is a question that has often not been answered. So we would be touching upon this theme and this question in some detail in the final module of the specific course. But having said this, if we, for the sake of argument and for the sake of clarity, define law as body of rules framed by institutions that are recognized as ones capable and authorized to frame rules, then we know that there are certain institutions in our legal system that are recognized to frame rules. And we will be emphasizing on them in the third chapter, which is the third chapter in our reading material, the institutional sources of law, which starts from page number 9. Now, if you look at this specific reading, you'll find we have divided the various institutional sources of law in 4 or 5 major types. Some, and most of these in fact should be fairly self-evident to you, given your existing familiarity with Indian legal system. And we speak of constitution as a preeminent, as the primary source of law. In fact, in constitutional democracies, constitution is the one which would be seen as the grand norm, would be seen as the primary rule or the primary body of laws which defines and which gives legitimacy to every other branch of law. And we need to understand that constitutions have or seek to define the role of state, seek to define the powers of the state, and conversely define the rights of individuals against the state. It also provides for a framework of governance where powers and limits of individual branches of government are defined. And in that sense, constitution gives us the overall skeletal framework for governance in a country. And based on the power, based on the authority given by the constitution, other sources of law are framed and other institutions frame sources of law. But constitution is the predominant, is the grand, is the fundamental law of any constitutional democracy. And we also need to appreciate that constitution did not be written. In fact, if you look at the British constitutional monarchy, They don't have a written constitution. If you look at Israel, they don't have a single written constitution as such. They have a range of laws that they call as basic laws, which cumulatively constitute the constitutional framework. So we may have countries that may not have written constitutions, but most countries these days have written constitutions. And as we will discuss later in your constitutional law course, there are certain elementary virtues in having a written constitution, and that's exactly why more and more states at this day and age are gravitating towards having written constitution, to have a clear charter of rights, to have a clear charter of duties, to have a clear charter of governance and framework of governance that defines the powers and limits of state and various branches of state or various agencies of state. So this is what we mean by constitution. As opposed to this, we also have something called as statutes or statutory law, or what we often describe as acts. So we have laws made by the parliament, which are called acts, which are framed by two houses of parliament and then approved by the president, subject to some exceptions where the law may be passed only by one house of the parliament, that's Lok Sabha, when it comes to money bills. But generally, otherwise, a bill is introduced in one house, it's passed in that house, it's introduced in another house, it's passed in another house, and thereafter it goes to the president for his approval. Now, traditionally, in common law countries, statutes were not as significant as judicial decisions. Statutes have generally occupied a secondary status, but over the last 200 years or so, statutes have become more and more critical, and as the role of state has expanded, role of statutes have also expanded, because the state has to exercise any power. The state has to regulate the telecom sector. You need a statute to govern the regulatory powers of the state. If the state has to set up a nuclear and regulate a nuclear energy sector, then we need a law governing the nuclear sector. If we are thinking of creating special norms on tort liability, then it may make sense for the parliament to create or enact a legislation on special civil liability. If we believe that certain special crime has to be created, so now we believe that domestic violence should be a crime, and as it has been turned into a crime for many years now, we had a special statute which provided for criminalization of domestic violence. So we find more and more statutes coming up these days, and as the role of the state is expanded from a police state to a welfare state, that is a state which is primarily meant to maintain law and order and administer justice, to a state that also performs a range of social welfare functions, where it carries out and provides hospitals, where it maintains old age homes, where it maintains social security schemes like Provident Fund, where it maintains schemes like employee state insurance, where it runs corporations like Life Insurance Corporation, where it runs banks. More and more statutes have been enacted to empower the state, to authorize the state to carry out all these multitude of functions that a modern welfare state is expected to carry out. So in that sense, we have seen a massive proliferation of statutes. If you turn to page 10 of your reading material, you'll find examples of some fairly absurd statutes that are still very much on statute books. And even as they do illustrate the absurdity of certain statutes, they also speak to the power of parliament. They also speak to the expansion of statutes as the dominant instrument of regulation. Apart from statutes, apart from constitution, we also have something called as ordinance, something that has become fairly topical right now given the misuse of, or arguably a misuse of, ordinances by the recent government, where on same matter ordinances have been reissued. But we need to understand that our constitution recognizes the fact that at times emergency legislative measures may be necessary when the parliament is not in session. So we have under Article 123 of our constitution, President has been authorized to promulgate ordinances which are like stopgap legislation, to be promulgated at a time when the parliament is not in session. This is meant as an emergency measure to address immediate needs, immediate urgent legislative concerns that may not and that cannot wait for the parliament to reconvene. But these are only stopgap measures because all ordinances have to be approved by the parliament within a certain framework of the, or within a certain time limit, and if that's not approved by the parliament, then the ordinance lapses. But generally, within 6 weeks of the reconvening of the parliament, every ordinance has to be approved by the parliament, and thereafter it becomes a full-fledged law. Till then, or in absence of such an approval, it lapses. But this is a stopgap measure that we need to understand. Apart from statutes, apart from ordinary ordinances, there is another instrument called the delegated legislation. An instrument called the delegated legislation, a sort of a mix between parliamentary law and executive lawmaking. And then there is also case laws, laws made by the judiciary. Due to paucity of time, we'll stop here. In the next session, what we'll do will be to discuss delegated legislation as well as case laws or judicial judge-made laws, and as well as what are described as informal rules in some detail in the next session. But what we have done till now is to explain to you what are the different major sources of law, and we've explained what we mean by constitution, we've explained what we mean by statute, and we've explained what we mean by ordinances that our constitution allows under Article 123 and 213 at the state level and 123 at the central level, that where the parliament is not in session, the president can promulgate ordinances to take care of urgent needs. And before that, what we did was to look at the role of morality, look at social acceptance in defining law. So in identification of what is that definitive character of a legal rule, what is that that turns a rule into a rule of law. And even before that, what we did was to look at a general introduction to what we mean by different techniques of legal reasoning. So we'll stop here. As I said in the beginning of this session, if you have any queries, if you have any doubt, I would advise that you write to me, or you can drop into my office at any time and get these doubts resolved. But I would advise again that it may help to go through the prescribed readings before listening to this particular video. So for this particular session, as I already mentioned at the very beginning, that you need to read up to page 13 of your reading material, and that will give you a decent sense of the themes that we have discussed in this specific session. Alright then, thank you so much. What I'll do would be to put this up on YouTube, and for the next session, similarly, I'll record this in a 1 hour session and put this up on YouTube. Thank you.